Hello and welcome to LiveLaw Daily. I'm your host Devojit Das. Today, August 3rd, is observed as National Heart Transplantation Day, marking the first successful human-to-human heart transplant performed in India at AIIMS, New Delhi. It was in 1994 under the leadership of Dr. P. Venugopal. Coming back to the developments from India's courts, here are today's top legal stories. Our first story deals with a Supreme Court case that raises an unusual question. Can an election result be rewritten after the Assembly's 5-year term has already ended? That's the unusual legal question the Supreme Court found itself dealing with today in a case arising out of the 2016 Tamil Nadu Assembly elections. The dispute is from the Radhapuram constituency, where AIADMK's Inbadurai was declared elected by a slender margin of 49 votes. His rival DMK leader M. Appavu challenged the result, arguing that several valid postal ballots cast in his favor had been wrongly rejected. The Madras High Court ordered a recount in 2019, but before the result could be declared, the Supreme Court stayed the exercise, and that interim order remained in force for nearly 6 years. When the High Court finally decided the election petition this May, it concluded that Appavu had in fact won the election by 103 votes. Despite the Assembly term having ended in 2021, it notionally declared him the successful candidate, directed official records to be corrected, and barred Inbadurai from claiming MLA pension for that term. The High Court also made pointed observations on the delay, saying that the Supreme Court ought to have decided an important legal issue instead of leaving it open. That order was challenged before the Supreme Court today. Senior advocate Mukul Rohatgi, appearing for Inbadurai, argued that the High Court's judgment was legally unsustainable and that its remarks criticizing the Supreme Court were wholly inappropriate. A bench of Justice B.V. Nagratna and Justice R. Mahadevan has now issued notice in the appeal and stayed the operative directions of the Madras High Court until further orders. Our second story deals with a case that has been in the public spotlight for over 2 years now, ever since some of India's top wrestlers took to the streets accusing former Wrestling Federation of India chief Brij Bhushan Sharan Singh of sexual harassment. A Delhi court today acquitted BJP leader Brij Bhushan Singh as well as former WFI Assistant Secretary Vinod Tomar in the criminal case filed on the complaints of several women wrestlers. The order was passed by Additional Chief Judicial Magistrate Ashwini Panwar at the Rouse Avenue courts after reserving judgment earlier. The trial had been conducted in camera with senior advocate Rebecca John appearing for the complainants, while Singh was represented by advocate Rajiv Mohan. The case had reached trial after charges were framed against Singh in May 2024 under the provisions relating to sexual harassment, outraging the modesty of women and stalking. Tomar was also facing a charge of criminal intimidation in relation to one of the complainants. Singh, however, had earlier been discharged with respect to the allegations made by one of the complainants, and the separate POCSO case involving a minor wrestler had already ended with Delhi police filing a cancellation report. The allegations against Singh related to incidents said to have taken place between 2016 and 2019, including at the WFI office, his official residence, and during overseas events. With today's judgment, both Brij Bhushan Singh and Vinod Tomar stand acquitted in the case. Our third story deals with another important hearing at the Supreme Court on the student protest cases, where the bench today clarified that states are free to close or withdraw FIRs against student protesters if they choose to do so in accordance with law. The clarification came because the court's July 28th order, which allowed the investigations to continue, had created uncertainty over the union government's commitment to withdraw cases against students as part of the understanding that brought the protests to an end. Solicitor General Tushar Mehta told the bench that the government remained committed to that assurance, but explained that criminal law does not permit an FIR to simply be withdrawn. Instead, authorities may have to file closure reports, seek withdrawal of prosecution, or approach courts for quashing. Justice Joy Malia Bagchi responded that the court could engineer an appropriate legal process to achieve that. The bench also clarified another important point. Its earlier direction protecting students with no criminal antecedents from coercive action will apply only to those without grave or heinous criminal cases, addressing concerns that even minor offences could unfairly disqualify students. The hearing also saw wider issues being raised. Senior advocate Gopal Shankar Narayanan pressed for accountability over the alleged use of excessive force, including pellet guns, while senior advocate N. Hariharan questioned the use of facial recognition technology to identify protesters. The Chief Justice remarked that police officers responsible for brutality should not be protected, and also indicated that the courts would lay down a protocol governing the use of pellet guns during civilian protests. The matter will now be heard again in August 18th. Our next story deals with a significant judgment from the Supreme Court that could expand the protection available to women in certain live-in relationships. The court has held that Section 498A of the Indian Penal Code, which criminalizes cruelty by a husband or his relatives, can also apply to live-in relationships that are in the nature of marriage. The case arose from Karnataka, where a man sought to quash criminal proceedings against him by arguing that he and the complainant were never legally married, and therefore Section 498A could not be invoked. The Karnataka High Court rejected that argument, and today the Supreme Court agreed. A bench of Justice Sanjay Karol and Justice Koteshwar Singh held that denying women in marriage-like live-in relationships the protection of Section 498A would amount to discrimination under Article 14. As the court put it, if the law protects women from cruelty within a domestic relationship, that protection cannot disappear merely because the relationship lacks formal legal recognition. The bench, however, drew an important boundary. It clarified that this interpretation will apply only to live-in relationships that genuinely qualify as relationships in the nature of marriage, where an intention to marry can be established. The ruling is also confined to Section 498A alone and does not automatically extend to other provisions of criminal law. At the same time, the court reiterated that the safeguards laid down in the Arnesh Kumar judgment against unnecessary arrests must continue to be followed in such cases. Our next story deals with a hearing before the Supreme Court on the rights of transgender persons after the Parliament's recent amendments to the Transgender Persons Protection of Rights Act. The concern before the court was this: what happens to people who had already obtained transgender identity cards, changed their official documents, or were in the middle of gender-affirming treatment before the new law came into force? A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana indicated that rights already vested in transgender persons should not ordinarily be disturbed. Justice Bagchi observed that since the 2026 amendment is prospective, it cannot automatically take away rights that have already accrued. He added that even if a person's status is to be cancelled on allegations of fraud, they must first be given notice and an opportunity to respond. The Solicitor General Tushar Mehta defended the amendment, saying that the earlier system of self-identification had created practical and legal complications. However, he assured the court that concerns raised by the petitioners would be examined. Senior advocates Jayana Kothari and Arundhati Kajju argued that many transgender persons now face uncertainty over their identity documents and ongoing treatment. The court, however, stopped short of passing a blanket interim order, saying individual cases involving genuine hardship could be brought before it. The matter will now be taken up again on August 17th. Our next story deals with the Trinamool Congress's challenge to the Enforcement Directorate's decision to freeze some of its bank accounts in a money laundering case. The matter reached the Supreme Court after the Calcutta High Court refused interim relief to the party, allowing the ED's freezing order to continue. The agency has frozen 3 HDFC bank accounts allegedly containing around 440 crore rupees, claiming the funds are linked to its investigation into suspected money laundering involving payments made towards the alleged acquisition of an aircraft and a helicopter. Appearing for the ED, Additional Solicitor General S.V. Raju argued that not all of the parties' accounts had been frozen and that over 164 crores remain unattached. On the other hand, senior advocates Kapil Sibal and Manika Guruswamy, appearing for Trinamool Congress, argued that the party's functioning had been severely affected, and even routine expenses, including employee salaries, becoming difficult to meet. A bench of Justice M.M. Sundaresh and Justice P.V. Varale made it clear that it was not examining the merits of money laundering allegations, since those issues are already pending before the High Court. Instead, Justice Sundaresh proposed a middle path. The bench suggested that some funds could be placed at the disposal of the High Court appointed administrator, exclusively to meet the party's day-to-day administrative expenses while the legal challenge continues. The matter has now been adjourned to enable the Enforcement Directorate to seek further instructions on that proposal. Our seventh story deals with the Calcutta High Court order passed in the middle of the ongoing special intensive revision of electoral rolls, where the court stepped in after a student's PhD admission was put on hold. The petitioner, Muhammad Ayan Nawaz, had secured admission to the PhD program in physics at IIT Kanpur for the 2026-2027 academic session. But according to him, the admission process came to a standstill after his name was deleted from the electoral roll, while his appeal before the SIR Appellate Tribunal remained pending. He approached the Calcutta High Court seeking one thing: an early decision on that appeal so that his admission wouldn't be jeopardized. Justice Krishna Rao noted that the petitioner's admission was effectively waiting on the outcome of the electoral roll dispute. Given those circumstances, the court said that the matter deserved urgent consideration and requested the appellate tribunal to decide the appeal as early as possible, preferably within 1 week of receiving the order. With that direction, the High Court disposed of the writ petition. Our final story deals with an unusual pilot project the Delhi High Court hopes could become a model for managing the city's growing stray dog population. The court has directed the Municipal Corporation of Delhi and the New Delhi Municipal Corporation to identify one ward each and organize a pilot camp for the sterilization and vaccination of stray dogs. A bench of Justice Dinesh Mehta and Justice Rajneesh Kumar Gupta said that the exercise should be carried out in consultation with the court-appointed amicus. Importantly, the bench directed that the residents be informed in advance that the dogs brought to these camps will not be sent to dog pounds or removed permanently, but will only be sterilized or vaccinated before being returned. During the hearing, the Municipal Corporation of Delhi informed the court that while there is no official census, Delhi is estimated to have around 8 lakh stray dogs. The civic body also suggested introducing microchipping as part of the pilot project, while another council suggested coordinating with local animal feeders to make the process easier. The bench said that the objective was to build public confidence and demonstrate that human sterilization programs can be carried out systematically without harming the animals. The matter will now be taken up again on September 1st, as the court continues monitoring compliance with the Supreme Court's direction on stray dog management. And that wraps up today's edition of LiveLaw Daily. If you'd like to read any of these stories in greater detail, you'll find links to all our reports in the description box below. For continuous coverage of the Supreme Court, the High Courts, and the legal developments from across the country, visit livelaw.in. Thank you for joining us, and we'll see you again tomorrow with more from the world of law.